And we are rolling. Hi, David.
Hey, Mark, how are you?
Good. So this is Mark Goldberg of UN Dispatch and also the host of the new podcast series, Global Dispatches Podcast, which you guys should check out if you're into these kind of wonky discussions on foreign affairs and foreign policy. And I'm speaking with.
This is David Bosco at American University School of International Service.
And you are the author of the excellent book about the International Criminal Court, Rough Justice.
Right.
And we are going to spend the next several minutes, I don't know, maybe like a half hour or so, talking about the International Criminal Court. And wow, there is actually a lot to talk about. So we are recording this conversation on Friday morning. And maybe like an hour ago, I got an email press release from the Office of the Prosecutor of the International Criminal Court saying that they are opening a preliminary investigation into Palestine.
Right.
So now this, as I understand it, is more of like a pro forma sort of thing that every time, someone kind of requests an investigation that the prosecutor has an opportunity to oblige them by just kind of making sure that the ducks are in a row, so to speak, that an investigation could proceed if it needs to proceed. How would you describe like the preliminary investigation stage or the preliminary? It's not even called an investigation, right? It's a preliminary examination.
That's right. That's right. No, I think you're right that there's nothing surprising about this. I actually thought this might have happened a few days ago. But the reason the prosecutors' procedures say whenever a state attempts to give it jurisdiction, using, and getting into the weeds a little bit here, but Article 12.3, there's a provision, Article 12.3 of the statute, which says that even a non-member state, and Palestine at this moment is a non-member state because its accession to the Rome Statute doesn't become active until April. So, but anytime a non-member state tries to give the court jurisdiction using this other procedure, the court, as a matter of routine, opens a preliminary examination, which is basically just saying we're going to start what can be a very long process of looking at this and trying to figure out whether crimes under the jurisdiction of the court have been committed and whether it makes sense to open a full investigation.
I guess so. Like the million-dollar question, therefore, is how likely do you think an ICC, a proper, full and proper ICC investigation of alleged crimes committed on Palestinian territory is? How likely is that to happen?
I actually think it's reasonably likely, and I think that because number one, Palestine attempted to give the court jurisdiction previously back in 2009 after in the closing days of the earlier Gaza conflict. And the prosecutor ruminated about that for several years, ultimately decided, I'm not sure whether Palestine is a state, which it has to be in order to accept the jurisdiction of the court. But that, from the prosecutor's standpoint, according to what the prosecutor has said, that debate is now over because of what the UN did back in November of 2012, when it recognized Palestine as a non-UN member observer state. And that was an overwhelming vote. And so the prosecutor has said, basically, from our perspective, the question of whether Palestine is a state is settled. So that means that's not an issue now, at least from the prosecutor's standpoint. What's at issue in any preliminary examination, which is, have crimes under the jurisdiction of the court been committed? And I think the court would be hard-pressed to find that there have not been crimes, widespread war crimes that have been committed on the territory of Palestine over which it would have jurisdiction. Now, there are some complex questions about what exactly is Palestinian territory. There are some complex questions about whether an investigation would be proper given this complementarity principle that the court operates by, which says that if a national jurisdiction, if a national court system is looking into crimes, then basically the ICC is supposed to step back. But if you look at the totality of the situation, you've got a lot of crimes, apparent crimes that were committed during the Gaza conflict. I think the clearest ones were by Hamas. And there's not a lot of evidence that those are the subject of a court investigation.
But can I stop you there? But wouldn't they be if Palestine accepts the ICC's jurisdiction,
Yeah,
then they're accepting an investigation of all crimes allegedly committed on Palestinian territory, not crimes allegedly committed by
that's
Israelis.
correct.
And so your point about complementarity, which I think is a crucial one for people to understand. So this is basically, and this isn't like one of the underlying principles of the ICC, which basically says that a local jurisdiction is the first and most appropriate place
Yes.
to investigate alleged crimes of against humanity and alleged war crimes. And it's only if that jurisdiction is unable or unwilling to proceed with an investigation that the ICC's jurisdiction kicks in.
Yes.
This, so far in the history of the ICC in practice, has meant that, for the most part, the ICC has really only intervened in places or countries that don't have a well-functioning judiciary system,
Yes.
that have just very, very weak judiciaries. This suggests to me that the prosecutor has a pretty big, and the court in general has a pretty big out when it comes to investigating Israelis, because Israel does have a strong and functioning judiciary, and they have, probed questions regarding alleged war crimes in Gaza.
Yeah.
This is so. I think this is one important out that to me suggests that I think it's reasonable to assume that the ICC will not go forward with an investigation of Israelis. I think the irony of sorts of the Palestinian accession to the ICC is that it's probably more likely that Palestinians will come under the ICC's jurisdiction than it is Israelis, because there isn't as functioning a judiciary in Gaza or in the West Bank. So these, and as you said, the crimes allegedly committed by Hamas are probably like a little easier to prove
Mm-hmm.
than crimes potentially committed by the IDF.
Right.
So this to me suggests that, chances are, if anyone's going to land in sort of the dock in The Hague, which I think is a very, very low likelihood, but if anyone is, chances are the first person in there will probably be like a member of Hamas or a Palestinian.
I would agree with most of what you just said, but I think there's one important caveat. So when it comes to kind of war crimes that might have been committed during the Gaza conflict, so was Israeli targeting of this building disproportionate? Did it not take adequate safeguards? All of those kinds of questions. Those are very difficult questions. Israel does have, notwithstanding a lot of domestic opposition to it, Israel does have inquiries underway into several incidents that occurred during the Gaza conflict. And so I think you're absolutely right when it comes to the Gaza conflict. The wild card, though, is settlements. Because if the ICC says that what we're looking at is the whole situation in Palestine, then you have a widespread policy of the Israeli government supporting, facilitating settlements on the West Bank. According to the Rome Statute, settlements in occupied territory, putting settlements in occupied territory is a war crime. And there, Israel does not have a plausible complementarity defense that it's something we are investigating on our own. Because from what I understand, having spoken to a number of Israeli jurists about this, while the Israeli Supreme Court has looked at a number of aspects of occupation policy and has scrutinized closely, for example, the separation barrier or the wall between Israeli territory and occupied territory, it has ducked the question of whether settlements themselves are legal and whether they might be violative of different provisions of international law. And so, and settlements is a big, widespread policy. I think it's going to be very hard for the court to say we can't look at that, and very hard for the court, if they do, to say that Israel has done what it needs to investigate this domestically. And one thing I would add is if the court does get to an investigation of Israeli settlements policy, that is extraordinarily explosive in a couple of respects, not just because it goes to kind of the heart of a key political issue, but also because when you think about who might be investigated what individuals might be investigated for war crimes under Israeli settlement policy, it's very hard to conclude other than that that investigation should be of senior government officials, ministers, prime ministers. And so the settlements question not only is really not subject to the complementarity defense, it goes right to the very top of the Israeli state.
And to the heart of international relations
Yeah,
and whatever resolution there might be to the Arab-Israeli conflict and two-state solution.
that's right.
I guess which suggests to me that the prosecutor would use her discretion to avoid having to pursue that line of investigation in order to avoid having to prosecute Israelis over the settlement policy. I
Yeah,
guess my question then to you is like, what discretion does she have to avoid that?
right. So that's a part of that. I think is going to be how the prosecutor's office defines the situation that they're looking at, because that word is kind of a word of art. What is the situation? And I suppose the court could, or the prosecutor could, try to define the situation as only the situation in Gaza, the Gaza conflict. But it's I think that's a tough argument to make, and to say, to say that the situation does not encompass the West Bank, that it's not all of Palestinian territory. It seems to me that I know Palestinian officials have specifically referenced settlements and talking about what they want the ICC to look at, which isn't determinative. They don't decide what the ICC looks at. But I think it would have to be it would be a tough line for the prosecutor to say, I'm only looking at the Gaza conflict but not looking at settlements. So yes, I think there's in the book I try to argue that the court and the prosecutor have been very cautious thus far. They've tried to use their discretion to avoid getting into really deep political waters, but I don't think this is going to be easy to avoid, and that's why I think we then get to questions about could there be some other mechanism of kind of forestalling or limiting ICC involvement, and that brings us to the UN Security Council, I would say.
Mm-hmm. One last question before I talk about the Security Council.
Yeah.
It's the subject of your other book.
Yeah.
But I guess so. It seems to me that the prosecutor has a great interest then in delaying this or slow walking this.
Yes.
And I would imagine that that's probably going to be her tactic, right? That just to keep this thing like dragging out. Maybe political circumstances might change 2 or 3 years from now,
Mm-hmm.
or at some point in the future that might perhaps reduce the Palestinians' desire to seek justice through the International Criminal Court. Maybe there's a breakthrough in the peace process,
Yes.
for example. So I mean, it seems to me that's probably the likely strategy, right?
Yeah, and there is a lot of evidence if you look at how the court has conducted preliminary examinations, how the prosecutor has, that for example, in Afghanistan, the prosecutors had a preliminary examination going on there since well before 2009, and it's very hard to conclude that political considerations and the possibility of an investigation there running into U.S. detention practices hasn't been a factor in why the court hasn't opened a full investigation there. So I think there's a lot of evidence that the court has used the preliminary examination process to kind of delay stuff that is really quite sensitive for it. But it's gotten a lot of flack for that as well. And, I would say the court's going to be under real close scrutiny on this. And if it does seem to get into that mode of kind of dragging out an preliminary examination forever, that's a serious legitimacy problem for the court. If it's really apparent that for political reasons, it's as you say, slow walking a full investigation.
And so you're saying the other way to block an ICC investigation is for the Security Council to vote on it.
Yeah.
But by the strictures of the Rome Statute that created the court, a vote requires unanimity, right, in the Security Council in order to block an investigation. So presumably, any one member of the country could, any one member of the Permanent Five
Right.
could veto an attempt to delay an investigation.
That's right. That's right. It requires an affirmative resolution of the Security Council, just like any other resolution and it has to be under Chapter 7. And that raises some really interesting questions, because certainly if say the U.S., which is the most likely to support, I suppose, a deferral, if they were to come to the Security Council and say, hey, we want to pass a resolution that freezes an ICC investigation, and that's all the resolution was going to say, I think that would be a non-starter in the Security Council. But I think what is really interesting is what if it were packaged with some other measures that the United States is not wild about but could live with. So, for example, there was an attempt in the Security Council to get a resolution recently imposing basically a deadline, saying, we've got to have, either we've got to have full negotiations or we've got to have an end to the Israeli occupation, and that's a more extreme version. But we've got to have, a deadline here for making progress on this. Or alternatively, there could be some provision in there about Israeli settlement policy. You could, for example, have the Security Council say, under Chapter 7, we order Israel not to construct any new settlements in the West Bank. Those, if you packaged an ICC deferral with some of those other measures, then you're getting into something which I think could be viable if we look at the interests of the Permanent Five and potentially of the non-permanent members as well. Because let's remember, I don't think any of the P5 see ICC involvement in Palestine as a useful thing. Even Britain and France, who are ICC members and supportive of the court, I don't think they think this is a good thing. Russia and China have no love for the court, and in general, I don't think would have a problem sidelining the court. But the question would be, could you strike some kind of package deal that the U.S. can live with and that the other members can live with? I think it's within the realm of possibility.
So I wanted to switch gears and talk about another big thing that's happened with the court in the last week, which is the surrender of Dominique Ongwen to U.S. forces in the Central African Republic. So this was a deputy leader of the Lord's Resistance Army led by Joseph Kony, who, under circumstances that are still somewhat unclear, seems to have turned himself in or have had himself turned in to American forces that were stationed in the Central African Republic, ostensibly to look for Joseph Kony and the Lord's Resistance Army. So this, I think, case brings up some pretty interesting questions about the court, and I think about also the morality of war crimes investigations. And I'd be curious to get your take. So Dominique Ongwen, was almost certainly is alleged and probably, I would say guilty of orchestrating pretty horrific mass atrocities and abuses of people as a deputy leader, as a big part of the LRA. However, Dominique Ongwen was abducted and conscripted into the LRA at the age of 10. So he was a child soldier, and he kind of rose through the ranks to become a leader and a war criminal. So I think, so my understanding of the law is that the law is pretty unambiguous, that you are responsible for crimes you commit after the age of 18. But morally, it seems somewhat problematic to prosecute someone who is abducted and conscripted into into an army at the age of 10.
Yeah.
I'm wondering how you sort of try to make sense of this.
Yeah, it is. First of all, I think the first thing to say is this is a good thing. This is a good thing, period, that he was apprehended. It's a good thing also for the court, which has had trouble getting a hold of people who have been indicted. And the LRA, indictments have been out there longer than any other indictments. And so, I think this is a good thing. And it's a good reminder that, I think the ICC gets a lot of flack for having been ineffective thus far. There's a lot of talk about how, people who've been indicted are roaming free, and that's, Omar al-Bashir is still the president of Sudan and traveling around the world. And this is a good reminder that, if we look at war crimes courts, things often start slowly, but that in the long run, they can end up getting hold of an awful lot of people that maybe it seemed like they weren't. And, here it's relevant to reference the experience of the International Criminal Tribunal for the former Yugoslavia, which also started off very slowly, had only some minor people in custody. But by the end of its life, and we're right now approaching the end of its life, it basically had gotten hold of almost everybody that it indicted. So this is a good reminder that, international justice can be a long game, and that a court that looks weak at various points may have the last word. But I think you're absolutely right that this raises really difficult moral questions. I haven't, I mean to, but I haven't yet kind of looked closely at kind of what some of the defenses, the kind of jurisprudential defenses that could be raised by Ongwen and his lawyers, who I assume will be court-appointed lawyers. And, they'll get to things like, what kind of mental capacity did he have? Is he essentially so damaged by the experience of having been a child soldier that he shouldn't be considered kind of mentally fit to stand trial? So I suppose you could get into that kind of question. But I think ultimately where this is most likely to come out is not so much in the question of guilt or innocence, but in the question of sentencing, assuming there is a guilty verdict. Because the judges, if I'm recalling the sentencing provisions correctly, have some discretion there. And I think they might very well be able to take into account, his experience of having been abducted as a kind of mitigating factor.
Yeah, I mean, you're obviously sympathetic to the fact that he was abducted
Right.
into the LRA at the age of 10,
Right.
but it's like hard to be, sympathetic to the fact that at the age of 20 something, he was
Yeah.
leading the LRA and abducting children himself
Yeah.
and allegedly, orchestrating pretty horrible, mass atrocities and mutilations and murders and rapes. So
Yeah.
it's just kind of tough.
It is tough.
It's very tough.
And he was, from the court documents and the public accounts that we have, he was not just kind of normal horrific stuff, but stuff where you're basically going into villages and, as you said, systematically mutilating people in order to spread terror and, just horrible stuff. So I find it hard, based on what I know at this point, I find it hard to believe that his experience as a child soldier would be a serious impediment to getting a conviction. But I do think it could be relevant, as I say, in the sentencing. But that's not to say, it's always hard for the court when one of these indictments that has been out there for a long time, one of these people is suddenly apprehended, because suddenly then you've got to get ready to go to trial. And as we've seen with a number of prosecutions, there are questions that arise about the evidence. There are questions that arise about witnesses. We saw with the Kenya investigation that some of the witnesses you were going to rely on dropped out. And so there may be all sorts of those kinds of questions that arise. It's been a number of years now between the indictment of this individual and the point at which he will stand trial.
One interesting thing about this saga was how the U.S. sort of played it.
Yeah.
So there's been this question that now that the ICC is open to an investigation in Palestine, that it would negatively affect Americans' cooperation with the ICC. It seems as if the U.S. Turned over Ongwen to Ugandan authorities with the expectation that Ugandan authorities would turn him over to The Hague, which seems to be sort of in place and what's happened. So in that respect, so far it doesn't seem to, like, the fact of the Palestinian investigation doesn't seem to have affected Americans' cooperation with the court.
Right.
I guess sort of my question is, if an investigation does go forward, one would expect that, I guess so far, American policy has been to punish the Palestinians for taking their case to the ICC, and there's a lot of movement in Congress
at least to threaten.
to do so. Yeah, at least a threat. So far, the threat hasn't been directly against the ICC, presumably because the U.S. really doesn't have much leverage over the ICC, right? I mean, the United States is not a member, and so it doesn't give any funding, so it really doesn't have much it can do. I guess, like, how do you see
Yeah.
this question of U.S. leverage going forward? Should and this is kind of like more of a Republican idea to punish the institution of the ICC as opposed to like the Palestinians
Right.
for taking
Right.
their case to the ICC. Although
Yeah.
it crosses party lines.
Yeah. It does cross party lines some, but no, I think you're absolutely right. I mean, so far what we've seen with the Obama administration is um, a kind of tightening of the relationship between the U.S. and the court in a number of discrete areas. So the U.S. Expanded its rewards for justice program to cover people indicted by the ICC. We saw with a previous warlord, Bosco and Taganda, the awkwardly named Bosco and Taganda. The U.S. helped facilitate his transfer from the U.S. Embassy in Kigali to the court. There's other ways in which the U.S. has managed its relations with the court. It's participating in the Assembly of States parties. It voted for,
which is the governing structure of the ICC.
The governing structure of the ICC. It voted for the referral in the Security Council of Libya to the court. And then there are other ways in which I suspect the relationship with the court has progressed, ways that we probably don't see. Things like, will the U.S. allow the ICC to interview witnesses on its territory, and those kinds of questions. What kind of specific investigative help it's going to offer, or perhaps intelligence that it's going to offer to the court. That stuff is largely out of public view. But it doesn't. The U.S. does not have an enormous amount of leverage because, just as you say, it's not a member. It doesn't, have annual dues. What it could do is say to the court, look, all of these little ways in which we've been cooperating with the court are going to be at risk if you do a Palestine investigation. And there will be no more referrals from the Security Council. There will be no more help out with other investigations. Diplomatically, we'll try to oppose the court. That would be an extreme step. That would be the kind of policy that I think like a John Bolton would have wanted the U.S., which the U.S. began on that policy in 2003 and 2004, but then even under the second Bush administration moved away from that when it acquiesced to the referral of the Darfur situation to the court. I think Bolton probably was arguing internally at that point, no, we should be consistently trying to marginalize the court, say we want nothing to do with this. That view didn't prevail. If the Palestine investigation really does move forward, and that's not the only thing that the U.S. is concerned about. The ICC prosecutor is also looking at U.S. detention practices in Afghanistan, and specifically mentioned for the first time in a recent report that it was looking at potential U.S. war crimes. So there are a couple reasons why the U.S. Would be nervous about the court. I think at this point, if things don't progress beyond where they are on Afghanistan, and if the court does drag out a Palestine preliminary examination, I don't think you'd see congressional action or steps by the administration to try to cut off all of those smaller avenues of cooperation. But if the court says we're going ahead with an Afghanistan investigation, or we're going to look at U.S. conduct, and if it goes ahead with a Palestine investigation, then I think that starts to move on to the table, and it would probably be, led by Capitol Hill and trying to compel the administration to do it, because the administration would prefer to keep its decent relationship with the court.
And like you said, this was the policy of the U.S. government from like 2003 to 2005, right? They would try to sign bilateral security agreements with as many countries as that would sign them,
right.
Guaranteeing U.S. Immunity from prosecution for crimes committed, by their soldiers on their territory. And if the countries wouldn't sign it, they would threaten to cut military or economic assistance to those countries.
That's right.
That was U.S. policy for the first few years of the court. And then that evolved eventually, I think, as the administration, the Bush administration, towards the second half of the Bush administration, started to find the court actually useful to advancing American interests. And Bolton, kind of was sidelined in that process.
Yeah, exactly.
As you said.
Exactly. And not just useful because, the U.S. was happy to have the court do a Darfur investigation. Not just useful, but also non-threatening, because the court, didn't do anything on Iraq, even though it could, in theory, have opened an investigation of British forces there. It basically seemed to be shying away from lots of situations, or a couple of situations that could have put the U.S. in an awkward position.
All right. Well, David, thank you so much. This was super helpful and interesting. Great. So I think we'll get this posted. Hopefully get this posted as soon as possible. It's pretty timely.
Great. So that's wonderful. Thanks so much, Mark.
Okay.